Welcome everyone to Questions, Stump the Lawyer. It's March 18th, 2025. This is the webinar from the Carpenter Law Firm. I'm Scott Carpenter. This is a presentation where you can submit your own question, and there is a question or a Q&A feature. I already have one question, so feel free to do that as we're going here. I'm going to get to those toward the end. I already have one question, so I'm happy to entertain those. I'm not going to do that quite yet. I have several that have been submitted. So I'm going to start with some of those that have been submitted. So question number one is really continuing a topic that we discussed last month, which is there time to keep our public street parking restrictions? This is from a statute that was enacted 2 legislative sessions ago in our planned community statutes, ARS 33-1818. And what it says is, after the period of declarant control for any planned community for which the declaration, of course, declaration and CC&Rs are the same thing, if the declaration was recorded before January 1, 2015, which is a weird qualifier, and where the planned community regulates any roadway for which the ownership has been dedicated to or is otherwise held by a governmental entity. Now realize here that people think this is about on-street parking, and people think it's about vehicles. They think it's about RVs and boats, but the statute never uses the word vehicle, never uses the word RV or boat. This is all it says. For a planned community that regulates any roadway where the ownership has been dedicated to or is otherwise held by a governmental entity. These are the only words in the statute. We have until June 30th of this year. We have April and May and June. We have 90 days plus what's left here in March to call a meeting of the membership. I had a client this week say, so we can do this at a board meeting. And I said, no, we cannot do this at a board meeting. We may need a board meeting to plan. We have until June 30th. We have all of April, we have all of May, we have all of June to call and hold a meeting of the membership. That's the owners. That's not the board. And we're going to vote on the question of whether to continue to regulate public roadways. This is a yes or no question. The owners are going to vote yes, or they're going to vote no. And the only question will be, should the association, and I'm going to call the association Green Acre, should Green Acre Association continue to regulate the public roadways? Now, what we probably have to say is, hey, owners in Green Acre, the association currently regulates the public roadways in the following manner. Section 5.3 says the following. You can't park overnight. No RV parking on the roadways. No overnight storage or whatever. Do you want the association to continue to regulate public roadways the way it does currently under Section 5.3 of the CC&Rs? Yes or no? And then the statute goes on to say, if the number of owners voting at the meeting on the question, what's the question? Should we continue to regulate public roadways? Is sufficient to constitute a quorum. So the first question is, did we get enough ballots back to cross over the threshold of the quorum? And then, once we answer that question, were there more yeses than nos? Then the association retains its authority to regulate those public roadways. So we send out all the ballots, And let's assume, as was the case with the client that I dealt with last week. It's Tuesday. I said this week. I meant last week. And they're confronting the question, do we have time to do this before June 30th? Their quorum is 20%. Big community, 3,000 homes. So it's a heavy lift before June 30th. So for every 1,000 homes, 20% is 200. They have to get 600 ballots back just to start counting the yeses and the nos. That's sort of a big, that's a big question. Can they get 600 ballots back in a mail ballot scenario? So they send out the ballots, but it's also a PR question. They have to send a cover letter. Hey, everybody, despite what it might look like when you drive through the community and see a bunch of cars in the streets, we regulate that under section 5.3, section 5.5, and 5.7. And some owners might say, it doesn't look like it. I see violations all the time. But we do regulate that. And we want to continue regulating it. Please vote yes. That's the PR piece. Now, maybe the board wants a gathering. Maybe they want to pitch it at a town hall, at a meeting. Well, it can be done by absentee ballot, but maybe we want to do an actual special membership meeting and vote there. Well, with 3,000 homes, if you only get 600 people to show up, we need all 600 to vote yes. Can't have any dissenters. Because then you've got your quorum is 600. Well, no, I'm wrong about that. I'm sorry. If 600 people show up, we just need more yeses than nos. So I'm sorry I said it that way. Forget what I said. If 600 people show up, that's the quorum. We need more yeses than nos of those that participated. We could have 301 yeses and 299 nos. That's the correct way of saying it. So when we do it by mail, we need 600 minimum to come back, and then we need more yeses than nos. So it can all be done by mail, but we could also do a town hall to get people oriented to the topic, or we could do all the PR by mail. So this is something that's still on people's minds, although I did a seminar on it last month. May have jolted some people to remember that this deadline is still out there, but there is time. There is time to notice the meeting. There's time to send out the ballots and get them back. But time is running short. The June 30th is going to be here before we know it. And if we do not vote to keep these restrictions, then by operation of the calendar and June 30th coming and going, these restrictions in the CC&Rs that regulate a publicly dedicated roadway in a planned community will become void and unenforceable after June 30th. That's what the legislature did 2 sessions ago. They said, if you don't vote to keep them, any restriction in the CC&Rs that regulates a public roadway that's dedicated to or is otherwise held by a governmental entity, then that restriction that regulates the roadway is unenforceable after June 30th, 2025. So that's question number 1. All right, question number 2, notice of membership meetings. There's a statute in the planned community statutes and in the Condominium Act, but I'm highlighting the planned community version that says before a membership meeting, not fewer than 10, you can't notice the meeting faster than 10 days or longer than 50 days. The secretary, now many secretaries delegate this function to a professional community management company. Not fewer than 10 nor more than 50 days in advance of the meeting of the members. This is not a board meeting. This is the annual meeting or a special membership meeting, such as a special membership meeting to consider voting to continue to regulate public roadways, for example, or a special membership meeting to vote on a special assessment or to vote on a CC&R amendment or something like that. Not fewer than 10 nor more than 50 days in advance of a meeting of the members, the secretary shall cause notice of the meeting to be hand delivered or sent prepaid by United States snail mail, I added that word snail, to the mailing address for each lot, parcel, or unit owner, or to any other mailing address designated in writing by a member. So the legislature is stuck in 1989. Hand deliver it or send it US mail, snail mail. And the legislature tends to conceptualize a 100 unit townhouse project at McClintock in Southern and Tempe or in Central Phoenix. This is what they imagine when they enact these statutes, that the on-site manager from the clubhouse could go door to door and knock out the hand delivery in about 20 to 30 minutes. But as we all know, who are participating in this webinar, that hand delivery is impractical at many of our master planned communities in Arizona. Hand delivery would be impossible at 10,000 Home Anthem north of Phoenix. It would be impossible at Verrado, west of Phoenix. There's a new community in Buckeye that's being talked about, that's being developed now, that is planned to have 100,000 homes. Teravalis. Hand delivery would never work in a community like that. So what has happened over the years is that it is entirely permissible for owners to designate with their association voluntarily that all notices are to be sent and received via email. Here's the language that an owner would use. In my voice, I, Scott Carpenter, hereby consent that all notices and communications from the association be delivered via email to me at my email address, scott@carpenter.law. So what's happened is many associations and management companies have inserted a document which we'll call consent to electronic communications into the requested closing documents and disclosures upon sale. There's no law or regulation that says an association cannot send such a document to a title company when there's a pending sale. I mean, we're sending all kinds of things to a title company. We're sending them a payoff on the delinquencies that are due when there's a transfer of ownership. We're sending title companies all kinds of things. Why not send, and I'm saying this rhetorically because this has been happening for years, why not send an additional document? Buyers will sign it. Consent to electronic communication and disclosure of email address. Most buyers will sign it to provide their email address, and it coincides with asking for the buyer to pay their assessments via ACH, withdrawal from their bank account. Buyers do that too, because buyers do not want to have to write a physical check each month with a coupon book. They want to have the money withdrawn from their account via ACH or electronic transfer. This is not a stretch in our modern world, and it reduces the friction required of, and let's just use the term in the statute, the secretary. And this is, it reduces the cost of the prepaid United States mail, which is up to nearly 70 cents per first class stamp. So the statute's outdated. The statute should be amended to allow the association to provide notices to be delivered electronically. But the workaround is to ask the owners to consent to notices and communications to be delivered electronically. But in many cases, what associations have done is they've simply done it anyway, even without the consent. What's the downside risk? We could have the discussion later, I suppose, in the context of a particular association that feels that it's risky. The risk is that an owner would not receive the notice of the meeting, and the owner would then make a legal claim, file a lawsuit, file a petition with the Department of Real Estate and say, well, because you emailed it to me without my permission, I didn't sign that consent. I didn't say, I, Scott Carpenter, hereby consent that all notices and communications from the association be delivered via email to johndoe@gmail.com. I didn't do that. I wanted my notice to be hand delivered or sent prepaid by United States mail. See, it's right there in the statute, 33-1804B. And you sent it to my email address, and I did not consent to that. I did not receive it. And because I did not receive it, I did not go to the meeting. And if I had voted at the meeting, I would have voted against continuing to regulate roadways. And the vote to continue regulating roadways passed by one vote. I would have voted against it. It would have been a tie. And a tie would have meant we would not have continued to regulate roadways. So you could see how this could, in theory, matter and why you'd want the consent. But I just created a pretty extreme hypothetical. I mean, that's a real stretch. But if you have the email address and you want to use it to avoid the first class mail, I just had to create a pretty elaborate hypothetical to get the association in trouble. We're generally not too worried about it, but it's better to have the consent. Better to have a written consent, and it's easiest to obtain it in the closing documents, as I suggest here on this slide. Question number 3, we see this from time to time, and it seems to be becoming more popular. An owner who live streams a board meeting. No more equipment required than an iPhone. This happened to me a few years ago. On a Friday night, there was a removal meeting, removing board members, and I was running the meeting, which sometimes I do. And a woman was, I was standing in the front of the room, and a woman came very close to me with her camera phone, and I didn't think much of it. And someone on the board told me to come over to the side of the room and said, "You're on Facebook Live right now." And I thought, well, that's interesting. I'm hideous. I didn't know I was going to need to be camera ready. I kind of made a joke about, I wasn't prepared for my Hollywood moment. And nobody thought that was very funny. I guess as a lawyer, you always have to be prepared for, um, being on camera. But that's not true, actually. We don't expect that. But here's what the statute says. Same in the Condo Act and the Planned Community Statute. The screen has the Planned Community Statute. Here's what it says. The board cannot require advance notice by a member of the audio taping or videotaping of board of directors meetings, but may adopt reasonable rules governing the audio taping and videotaping of open portions of the meetings of the board and the membership. But the rules cannot preclude the audio taping or videotaping by those attending. Note the words taping. Taping is the idea that someone's going to record to a medium that's going to reduce the events to a recorded medium. Whether it's tape, the old videotape, or perhaps a memory stick or something like that, and it's going to reside and be the property of the owner. Now, the rules that the board adopts cannot preclude the audio taping or videotaping by those attending unless the board records the meeting and makes unedited tapes available to members on request without restrictions on their use as evidence in any dispute resolution process. The statute explicitly says that the board can adopt reasonable rules governing the taping of open portions of the meetings. So over the years, I've helped many clients adopt these reasonable rules, and I've taken the position, without really any pushback, that the statute talks clearly about taping, which is reducing the meeting to this recorded medium, and we prohibit live streaming, and then adopt a social media policy that essentially bans an owner from recording the meeting and then posting it to social media, which includes YouTube. You can't live stream the meeting on Facebook, which maybe people aren't doing that anymore. I don't know. You can't live stream on YouTube or any other platform. There's many of them now. And essentially what people have been doing is they'll create a neighborhood Facebook group or some other online gathering place, but it's a dissenting gathering place, and they'll go to the meeting, set up their phone, or hold it up, almost always in an invasive kind of way, just in your face kind of. You could feel it the way I'm doing it right here. You can feel that someone's recording you just with the camera stuff kind of in your face. Even if you're watching me, you can kind of feel it when I do it that way, when you've been on the receiving end of it. And we adopt rules and regulations, no live streaming on any online broadcasting platform. And then once you've taped the meeting, recorded the meeting, taping, recording, we're not playing games with the words, you can't post it to any social media platform, Twitter, we'd have to list them. Any social media platform, Facebook, Twitter, Instagram. You can't create a reel on Instagram to poke fun at the board or just for any purpose whatsoever. I mean, basically what the statute says is you can record it. We can adopt rules. The the board can record the meeting, and we could make these recordings available, but essentially the owners can use them in a dispute resolution process. I've had clients recently who've struggled a bit because in the pandemic, they started using Zoom. And as it turns out, these Zoom recordings were being made, and these recordings are in the cloud. Are they held by the management company? Where are they? Can owners obtain the entire Zoom recording? It became kind of difficult to figure out who owned these recordings, how could owners get a copy. These Zoom recordings have actually become a bit of a problem. And I'm not trying to create problems by mentioning it, that these Zoom recordings have kind of fallen into the category of this last clause in this statute. If you look at the word, unless the board audio tapes or videotapes the meeting and makes the unedited audio or videotapes available to members on request without restrictions on their use as evidence in any dispute resolution process. Some boards and associations have accidentally have unedited video recordings of these Zoom meetings. They didn't even know it. They're not even aware of it, and may have to make them available on request, which is a difficult standard. And so we've been confronting some of these technological challenges with these Zoom recordings that we weren't even aware of. But the more important point I'm making here is that, and the question that I received was, can we stop people from live streaming board meetings? There is room under this statute and the language that says the board may adopt reasonable rules governing the audio taping and videotaping of open portions of meetings. There is room to argue that well-crafted, reasonable rules would allow a board to prohibit live streaming and adopt a social media policy. We've done it for lots of clients over the years. But let's concede that if someone's at a meeting and they're holding up their phone and we don't know exactly what they're doing, we wouldn't know if they were live streaming on a social media platform through a VPN. And if they don't tell us what they're doing, holding up the phone is certainly suggests that they're recording, but they can record. And if we don't know if they're live streaming or not, now we're just asking for a confrontation. And if someone else is recording in the room and they're recording the confrontation, we've actually now just created a potential fight between the manager or the board president and the person who's doing the live stream. And now that video might go viral. And now that's the more interesting thing that's going to happen at the meeting. The live streaming was problematic enough, but now there's a fight, there's a confrontation, and now that's gone viral, and we're all watching it the next day on Apple News on our phones. All right. Here's one that I get this question a good bit, and I got it before the seminar today. Is an annual audit, review, or compilation really required? This falls into the category of if a tree falls in a forest and no one heard it, did it make a sound? This hardly is ever, I'm not sure it's It's hardly ever litigated. Let's go through it real quickly. Here's the statute. Again, picking from the Planned Community statutes, although the same statute exists in the Condominium Act. Here's what it says. Unless any provision in the governing documents requires an annual audit by a CPA. If the documents require an annual audit by a CPA, do that. The board shall provide for an annual financial audit, review, or compilation of the association. The audit, review, or compilation must be completed no later than 180 days after the end of the association's fiscal year and shall be available upon request to the members within 30 days after its completion. How is this enforced? If there's a breach of the statute, what happens? And by the way, this is breached all the time. I saw one the other day where the statute, the compliance with the statute was 3 years. It hadn't been complied with in 3 years. For whatever reason, the accounting firm hadn't received the information, but there hadn't been compliance with the statute in 3 years. And there's no state agency to enforce this. These audit, review, or compilation, it's optional. It's multiple choice. Pick whichever one you want. Again, assuming that the governing documents don't require a full audit by a CPA, it's multiple choice, A, B, or C. Pick whichever one you want, or A, R, or C, audit, review, or compilation. Pick whichever one you want. The government doesn't care. The Attorney General doesn't care. How is this enforced? Well, any owner in the association has the power of enforcement. File a lawsuit in whatever county you're in Superior Court and ask a judge to enter a court order or injunction that would compel the association to hire an accounting firm to undertake the audit, review, or compilation. Or an owner could file a petition with the Arizona Department of Real Estate. Now, the Arizona Department of Real Estate does not have the power to enter a court order or injunction to compel the completion of the audit, review, or compilation. But an owner could go there and explain the situation, and the administrative law judge could make a finding that the association is in violation, and the association hopefully would hire an accounting firm to do the work. Now, why do we have this requirement? Well, a number of years ago, there were a number of cases of embezzlement in associations, managers, directors, treasurers, a couple of bad management companies, we could say, managers, whatever. And there was some thought that if every year an association were to undertake a review of its financials, even a compilation, which does not detect fraud and theft and embezzlement, and an audit doesn't either. A forensic audit is designed to catch fraud and embezzlement. But if there were some level of look at books and financial statements, then perhaps if every association in the state were required to have a third party review financial statements, and perhaps we'd have a better chance at catching fraud and embezzlement. Has it worked? Well, there's still fraud and embezzlement. Hasn't been perfect, but that was the intent. So, but if we don't have perfect compliance with the obligation to undertake this audit, review, or compilation, then we're not going to catch all fraud, embezzlement, and theft. Um, but it was never going to do that anyway, because these financial reviews of financial statements and books of associations are imperfect tools to catch fraud, theft, and embezzlement anyway. And I'm not an accountant, I'm a lawyer, but I do know that these are imperfect tools to catch fraud, theft, and embezzlement. But that's how this requirement would be enforced, is an owner would have to go to court. But we also know that the idea that members would ask to see the audit review or compilation within 30 days after its completion is also a bit of a running joke in Arizona. I don't mean that it's a funny joke, but owners do not ask to see the audit review or compilation. Associations in the aggregate spend many thousands of dollars with accounting firms across the state to complete these tasks across Arizona's 10,000 community associations. And let's assume that there's compliance with this obligation to undertake these tasks. Many thousands of dollars, hundreds of thousands of dollars in accounting fees are paid to have this work done for these reports, these audits, reviews, and compilations to go into the board packet of boards of directors. And in many cases, if not, dare I say, most cases, to go in the board packet of the board of directors. And that's it. That's where the task terminates, and no member ever asks to see it. And that's okay. That's no judgment on the membership. But these audits, reviews, and compilations that are, in theory, if you read the statute, which is completely reproduced on the screen, there's no more to the statute than what's on the screen. These tasks that are designed to help the members be assured that there's no funny business. The members never ask to see them. But again, no judgment. I don't ask to see it in my association. So I guess I'm part of the problem. Okay. But I just did that. Okay. Number 6. This is a curious one. For many years, I had a client ask about this the other day. We've had, really since 9/11, when the legislature decided if people want to fly the American flag, if people want to fly the American flag, they have to be allowed to do that. And I remember it vividly. This year will be 24 years since 9/11. And the legislature said that next January, if someone wants to fly the American flag, HOAs can't stop them. And when I was doing my volunteer lobbying at the legislature, we said, of course, no problem. And ever since then, when the legislature has moved to negate covenants, use restrictions, CC&R provisions, it's been harder and harder to stop them, because they say, well, no matter what your CC&Rs say, this behavior has to be allowed, whether it's flags or solar panels or real estate signs or whatever, and you know how it's cascaded. So when it came to the flag usurpation of covenants or use restrictions, the legislature put something in the statute that has been largely ignored and forgotten over the years. And I had a client ask about it last week, and so I put it here in the seminar. What the statute says is that, and it's in both the condo and the planned community statutes, and it's been largely forgotten and ignored in many cases. It says the association shall adopt, must adopt, shall means must. The association shall adopt reasonable rules and regulations regarding the placement and manner of display of the flags prescribed by subsection A of this section. Well, subsection A is the section that says, no matter what your restrictions say, you have to allow the American flag, the Gadsden flag, the Indian Nations flag, the state of Arizona flag, the POW MIA flag, there's a whole list. And then it also says that the association rules may regulate the location and size of flag poles, may limit the member to 2 wall-mounted flagpole holders, 3, 4, and 5. Now, in italics, I highlighted 2 of these. May regulate the location and size of flagpoles. And then number 5, shall not prohibit installing a flagpole. The portion that's in italics is just in the Condominium Act. 2, 3, and 4, and half of number 5, all of number 5 is in the planned community statute, but the portion that's in italics is in the Condominium Act. So the Condominium Act says the association rules may regulate the location and size of flagpoles and shall not prohibit installing a flagpole. So the Condominium Act is a little less, but the planned community statute has certain requirements for the association rules. But in both the planned community and the Condominium Act, in a planned community and a condo, all association in Arizona must have reasonable rules and regulations regarding flags. And a lot of associations don't have them at all, or it's okay if it's not a separate set of rules and regulations. The flag rules and regulations can be in the rules and regulations, but the rules and regulations need to have a section on flags, and it has to address these 5 requirements in a planned community, but at least the 2 requirements in a condominium. And for a lot of associations, they just simply don't have it at all, or need to be refined to remember that we have to have this mandatory flag rules and regulations requirement. So there's this sense that what would happen if we don't? Well, if we don't have rules and regulations that comply with the statute, then we run the risk that when somebody has a flag, or that we're going to do some enforcement activity that is rogue in the sense that we're off script from the statute, or it's rogue in the sense that it's off script from the rules if the rules are not in absolute compliance with the statutory requirement. The statutory requirement is verbatim as this slide suggests, a copy and paste from the statute when I do these presentations. So having rules that comply strictly with the statutory requirements and are strictly in compliance with the statute, and then when we do our enforcement, you do your enforcement, I should say, in compliance with your own rules, you are squarely within the statutory requirements. We're not going to get in any trouble, at least in theory. We're not too far afield from what the statutes permit and require. That's important, but it's also possible that someone could complain, although unlikely, to the Department of Real Estate and say the association's in violation of the statute because we don't have reasonable rules and regulations regarding the placement and manner of display of flags under the statute. The Department of Real Estate is available for owners to complain that the association is in violation of statute. That'd be a real stretch, but if somebody were upset with the board and wanted to just drag the association through that process, they could do it here. They could say, hey, I've reviewed the rules and regulations and we're not in compliance with ARS 33-1808B because I don't see rules and regulations regarding the placement and manner of display of the flags prescribed by subsection A of 33-1808. We don't want that to happen. Now, do you have owners in your association who would do that, pay the filing fee at the Department of Real Estate just to make the point that the association's out of compliance by not having rules regarding flags? It's a bit rhetorical. It's kind of a hypothetical question. I don't know if you have an owner that would do that, but it is within the realm of possibility because these rules regarding flags and these 5 components of the rules in a planned community and the 2 components in a condo are mandatory, and someone could do that if that's their emotional and personality disposition. All right, I'm going to turn to the questions you've posed in the Q&A. All right, our HOA is voting on retaining our ability to enforce parking. All right, we started with that. If the majority are in favor and we prepare a document to file with the recorder's office, what should the document say? The document has to be in compliance with the statute, and the document largely, if you're gonna DIY it, I'm hesitant to. I mean, it has to have the recording information of your declaration. I'm kind of hesitant to do it in this format. But basically, if I were drafting it for a client, it's got to end up in the title search of your CC&Rs. Whereas the declaration was recorded on this date at this recording number, whereas it was amended on this date with this recording number, whereas there was a second amendment on this date with this recording number, whereas ARS 33 dash pardon me here. Whereas 33-1818 required the association to undertake a vote before June 30th, 2025, whereas the association undertook the vote on May 15th, and at that vote, a majority voted to continue to regulate the roadways. And pursuant to 33-1818, ARS 33-1818, and majority voted in favor, and I would record something like that. That's the gist of it. But the important piece of the recording, if you're going to DIY it, not have a lawyer do it, is that when a purchaser buys in the future from the date of the recording that you're doing, a title company that's providing the governing documents has to find the CC&Rs, an amendment, the next amendment, and then they have to find your think something might have happened. May have been disconnected there. Thing. I think I I'm having a little trouble with my connectivity here. See if I can get it back. Okay. Does the legal duty to enforce include collecting member violation fines as part of enforcing the CC&Rs? Some associations are forgiving and erasing all fines once a member eventually complies with a violation notice, which can take months for compliance by some members. You know, the duty to enforce is really about compliance, and uh, fines are not part of the statutory lien. We cannot collect fines at closing from the statutory lien. Under the statute, you have to get a judgment for the fines first before they could be collected at closing from a title company. So the general standard practice in Arizona is once compliance has been achieved, collecting the fines is not so important. So the duty is to achieve compliance. So I think my answer to that would be not to be so obsessed with collecting the fines that you incur a bunch of legal fees trying to collect fines after compliance has been achieved. Most lawyers and associations and professional management companies, I believe, would take the position that once compliance has been achieved, that chasing the fines is not so important. How long must we keep the ballots for House Bill 2298? House Bill 2298, that's the parking regulations bill. That's where I started. It's part of the statute now, so I don't refer to it that way, but it's fine. We can do that. If the majority are in favor, that. How long would you keep the ballots for House Bill 2298? I'd keep them for at least 2 years. And I'm sort of making that up. Sort of, how long if I at least has asked who do we report results of the vote to? You really tell people, hey, the results are 320 to 180, and let them know you're going to record something with the county or just reporting the results to your own membership, and then we're recording that notice with the county recorder. That's the only person that really cares of the Arizona Corporation Commission. So I filed a complaint with the Corporation Commission concerning the violations. And the Corporation Commission wrote me back and said they don't police their statute violations. My question is, to whom or what do I turn to try and hold the board accountable? Well, that's certainly true, that the Corporation Commission is, they regulate utilities, they set rates for utilities. The Corporation Commission is not a regulatory body. They are concerned about creating corporate entities. They take annual reports for corporate entities, but they don't police how corporations behave. So that's all makes sense. Um, as I said several times in my presentation today, members can go to court, but in a co-op, the Department of Real Estate is not an option. So you can hire an attorney and file a lawsuit against the co-op. Or one thing I have not discussed today is you could elect different directors at the next annual meeting when their term is up. You could try to remove the directors from office using the process and procedure in the bylaws. There's always a way to deal with directors that are violating their duties or violating statutes or violating the bylaws. It's not always easy, but they campaigned to get on the board and were elected somehow. There's always, in theory, there's always a way to deal with that doesn't require a lawsuit or a hiring a lawyer and paying for that lawyer out of your personal checking account. Sometimes it takes time. It might take your own candidacy for the board, but sometimes, it's not a very satisfying answer to say, go hire an attorney and sue your own co-op. That's one option, but becoming politically active, running for the board, figuring out a way to remove bad board members, again, frustrating, friction, time, energy, and effort, but those are also options. Can a board member call a meeting of a COS to call for a resolution for an Article 5 convention to amend the US Constitution to fix the problems? I feel this is beyond the scope of using association buildings as it implies endorsement of this organization. I don't think I understand that question. If an HOA has a reserve study and sufficient funding for maintenance, can a special assessment legally be levied to do improvements over and above planned maintenance schedule and cost? A special assessment, if it has to be voted on by the membership and the membership votes for a special assessment in an environment where there is a sufficient funding for reserves and the membership votes for the special assessment, sure, and anybody can do anything. Often special assessments have to be voted on by the membership. So if the membership are persuaded to vote for a special assessment in an environment where there's a reserve study that's sufficiently funded, and the membership votes for a special assessment on top of that, that works. I think that makes a lot of sense if people want that. Here's a question. Is a town hall considered a meeting of the membership or only a meeting of the board as distinguished from a required annual meeting of the membership required by state law? Well, a town hall, the way we think of it in the industry, is a gathering of the members for informational purposes only, where we wouldn't call it to order and conduct business, conduct membership business. Membership business would be a vote, electing directors, voting on this street regulation question, for example, or voting on a special assessment like the question I just answered, or a different membership issue or question. So we end up with a gathering for informational purposes only. So in the loose vernacular of the industry, we tend to call that a town hall, informational purposes only, a gathering with for informational purposes only. But it's not a legal term that appears anywhere in statute, sort of a made up concept. Let's have a town hall where we just impart information, but we don't take any action. It's kind of like a city council that has a study session or an agenda planning session. And the hallmark of that from a city council standpoint is they don't vote on anything. They just hear reports from bureaucrats about the paving project, but they don't have any motions, they don't vote on anything. And so they call it a planning session. Boards do the same thing. Boards could have, of HOAs could have a planning session or a retreat, but the excuse is, well, we're not voting on anything. Well, the statutes are very clear that if board business is discussed and a quorum or more of the board is there, that's a board meeting, has to be open and has to be noticed. So a town hall is considered a meeting of the membership because association business is discussed. So the question is the town hall considered a meeting of the membership? I would consider it that way. Or only a meeting of the board. Well, if a quorum or more of the board is there, it's a board meeting for sure. If you notice it as a membership meeting and a quorum of the membership attends, it's a membership meeting. Same as the board. If a quorum or more of the board attends and association business is discussed, that's a board meeting. If you notice it as a membership meeting and a quorum or more of the membership attends, that's a membership meeting. So I think we're all on the same page about that. I got a note that my connection hasn't been great this webinar. I'm going to work on fixing that for next time. I apologize for that. That's all the questions for today. I'll work on my connection for next time. And thank you all for attending today. This is all the questions I have. Thanks.